Welcome to the deep dive. We're zeroing in on a really significant legal development today.
We are. We've got some fascinating documents here.
Yeah, specifically excerpts from a United States District Court order down in Texas. It's an order and opinion that just landed yesterday, May 1st, 2025.
Exactly. And this ruling, it really unpacks a legal challenge to President Trump's recent use of the Alien Enemies Act.
Right, focusing on Venezuelan citizens and this group, Tren de Aragua, or TDA.
That's the one.
Okay, let's get right to why this matters to you listening. This isn't just dry legal stuff.
No, definitely not.
It really touches on presidential power, how immigration laws get applied, and, the crucial role our courts play. So our goal here is to cut through all the complexity. We want to pull out the core knowledge, the key arguments, and what the court actually decided.
Think of it as your shortcut. Yeah, a way to get up to speed on a pretty intricate situation quickly.
Exactly. So what kicked all of this off? Where does this story start?
It starts with President Trump's proclamation that was issued back on March 15th, 2025.
Okay.
That proclamation is really the foundation for everything that came after.
Right. And this proclamation, it invoked a really old law, didn't it? The Alien Enemies Act.
Yeah, dusted it off, you could say.
So what exactly did the president declare about TDA and Venezuelan citizens?
Well, the proclamation formally labeled Tren de Aragua a designated foreign terrorist organization.
Okay, that's a specific legal term.
It is, and it asserted that TDA was carrying out an invasion or predatory incursion against the United States.
Invasion, predatory incursion, strong words.
Very. And based on that, the president stated that Venezuelan citizens aged 14 and older who are TDA members inside the U.S. and aren't citizens or lawful permanent residents, well, they could be apprehended, detained, and removed.
Under this specific law?
Yes, as alien enemies under the AEA. It's a pretty broad claim.
It certainly sounds like it, and I assume that didn't go unchallenged.
Not at all. It was challenged almost immediately.
Okay, let's talk about the lawsuit then. Who brought the case? And what were their main arguments against what the president did?
The challenge came from 3 Venezuelan individuals. Their initials are JAV, JGG, and WGH.
Okay.
They were all being held at the El Valle Detention Center down in Raymondville, Texas.
Ah, so that's why the Texas court.
Exactly. They filed their case using a specific legal tool, 28 U.S.C. Section 2241. It's basically a way for people who think they're being unlawfully detained to get a court to review their situation.
Like a habeas corpus petition.
Precisely. They argued their potential removal under the president's proclamation was illegal, and that it violated their Fifth Amendment due process rights.
So their core argument was, you can't use this old law against us like this.
That's the heart of it. They challenged the president's authority to even invoke the AEA in this context. And importantly, they also flat out denied being members of TDA.
What do they want the court to do?
They were asking for a permanent injunction, basically. A court order telling the government to stop permanently to prevent their removal under the AEA.
And were they just suing for themselves?
No, they also wanted to represent a larger group, a class action, for others in the Southern District of Texas facing the same kind of removal order.
Got it. So we have the president's action, the lawsuit challenging it. What did the court ultimately decide? What were the key takeaways from their ruling?
Well, the court's decision was pretty major. They started by acknowledging, the basics.
Like what?
Like, the executive branch does have the power to enforce federal laws. That includes immigration laws like the Immigration and Nationality Act, the INA.
Right, removing non-citizens who've committed crimes, that's standard procedure.
Exactly, that's under the INA. But the court said the central question here was different. It was whether the president could use this specific law, the Alien Enemies Act, against these specific people, Venezuelan TDA members.
And what was their answer to that specific question?
Their conclusion was clear. The president's use of the AEA in this situation, based on the March 15th proclamation, goes beyond what the statute actually allows. It's contrary to the law's plain meaning.
So the court said no.
Essentially, yes. The court ruled that the executive branch cannot rely on the AEA, based on that proclamation, to detain and remove the petitioners and the class they represent.
Wow, that's a significant check on executive power there. To really understand why the court said this, we probably need to dig into the Alien Enemies Act itself. What's the history behind this law? It sounds ancient.
It is ancient in legal terms. It goes all the way back to 1798.
1798.
Yeah, passed during a period when the U.S. was facing a possible war with France. It was actually one of 4 laws considered by a House committee focused on protecting commerce and defending the country.
So born out of a specific fear of imminent conflict, what was its original goal?
The main idea was to deal with concerns about non-citizens, aliens living in the U.S. during a time of potential conflict. The key provision, which is now 50 U.S.C. Section 21, gets activated under specific circumstances.
Which are?
A declared war, or an invasion, or a predatory incursion that's actually perpetrated, attempted, or threatened against the U.S. by a foreign nation or government. And crucially, the president has to issue a public proclamation.
So it needs one of those triggers and a presidential announcement.
Correct.
And if it is triggered, what powers does it give the president?
Really broad powers over anyone classified as an alien enemy. We're talking apprehension, restraint, securing them, removing them from the country.
Wow.
The president can also regulate their conduct, decide how much restraint is needed, set conditions if they're allowed to stay, remove those who refuse to leave. Basically, make any regulations deemed necessary for public safety during that time.
That sounds incredibly powerful. Has it been used often throughout history?
Not incredibly often, but it has been used mainly in wartime.
Okay, give us some examples.
Well, first, during the War of 1812, President Madison issued a proclamation requiring British and Irish subjects to report to U.S. Marshals.
Okay.
Then, World War I, President Wilson used it against German aliens, restrictions on weapons, travel, even potential confinement.
And World War II, I imagine it was used then.
Definitely. President Roosevelt invoked it right after Pearl Harbor, December 7th, 1941, declaring an invasion by Japan.
Immediately.
Yes. And the very next day, December 8th, further proclamations concerning Germany and Italy, citing a threatened invasion or predatory incursion.
Okay.
Later, after Congress declared war on Hungary, Romania, and Bulgaria, it was extended to their nationals, too.
So covering all the Axis powers eventually.
Right. And then an interesting twist in 1945, after the fighting in Europe stopped, President Truman amended the proclamation.
How so?
He authorized the removal of alien enemies, Japanese, German, Italian, Bulgarian, Hungarian, Romanian, if the Attorney General deemed them dangerous because they still adhered to enemy governments.
So even after the main conflict, it was used for removal based on perceived loyalty.
Correct, but notice the pattern.
Yeah. Every single time it was tied to a declared war or a direct military attack or threat. War of 1812, World War I, World War II.
Exactly. That historical context is really important for understanding the court's recent decision.
Okay, let's pivot back to the current situation then.
Yeah.
Venezuela and Nicaragua. What background do we need on them specifically?
Well, the U.S. government has been targeting what it calls transnational criminal organizations, or TCOs, for a while now.
Right.
Back in 2011, President Obama issued an executive order targeting their assets. The Treasury Department followed up with regulations defining TCOs, prohibiting support, but TDA wasn't actually on that first list of designated groups.
So TDA wasn't initially singled out.
Not in that specific 2011 action, but the U.S. has taken actions related to Venezuela more broadly.
Such as?
In 2017, the Treasury designated Venezuela's then Vice President, Tarek Zaidan el-Aissami Mata, as a foreign narcotics trafficker under the Kingpin Act.
Okay, targeting high-level officials.
Yes, and he was later indicted in the U.S. in 2020 for sanctions violations. More recently, and directly relevant to TDA, in July 2024, the Treasury Department did place Nicaragua on its sanctions list, calling it a significant PCO.
So TDA officially designated just last year. Has law enforcement been tracking them too?
Oh, absolutely. In December 2024, Interpol Washington announced they'd captured an alleged high-ranking TDA member in Tennessee.
In Tennessee, wow.
Yeah, and the acting director of Interpol Washington at the time, Jeffrey Grimming, specifically noted TDA as a significant threat to the United States as it infiltrates migration flows from Venezuela.
Okay, so clearly an organization causing concern for law enforcement and the Treasury. Now let's connect this back to President Trump's proclamation for March 2025. What specific claims did it make about TDA and the Venezuelan government? This seems crucial for the AEA invocation.
Absolutely crucial. The proclamation laid out several really serious claims. It said TDA is a designated TCO with thousands of members, many here unlawfully. It accused them of conducting irregular warfare and hostile actions against the U.S. It also linked TDA to another group, Cartel de los Soles,
Which it described how?
as a drug trafficking and terrorism enterprise sponsored by the Maduro regime in Venezuela. and it listed brutal crimes. TDA supposedly commits murders, kidnappings, extortions, trafficking.
So linking TDA directly to violent crime and the Venezuelan government.
Yes, and it went further. It alleged TDA engages in mass illegal migration deliberately to harm U.S. citizens, undermine safety, and destabilize democratic nations, all supposedly in support of Maduro.
That's a heavy accusation.
Very. It claimed TDA is closely aligned with, even infiltrated, the Maduro regime military law enforcement. It specifically mentioned TDA growing significantly when Tarek el-Assami, the guy sanctioned earlier, was governor of Aragua State and later VP.
So painting a picture of deep state collusion.
That seems to be the picture painted, yes. The proclamation stated Maduro has close ties to narco-terrorists, leads this Cartel de los Soles, and coordinates with TDA to, quote, flood the U.S. with narcotics.
Flood the U.S.
That's the language used. The conclusion drawn in the proclamation was that Venezuelan authorities have basically ceded control to groups like TDA, creating a hybrid criminal state.
A hybrid criminal state.
And that this state, through TDA, is perpetrating an invasion and predatory incursion against the U.S. That's the link back to the AEA language.
Okay, those are the administration's claims in the proclamation. Let's go back to the individuals who sued JAV, JGG, WGH. Can you briefly tell us about their specific situations? What led to them being detained?
Sure. JV said he came seeking asylum. He was actually arrested during his asylum interview back in February 2025.
At the interview.
Yes. He denied being in TDA. He was initially held in Pennsylvania, then moved to El Valley in Texas around March 9th, and told on March 14th he was being removed under the proclamation.
Okay. What are JGG?
JGG claimed he came to escape torture, saying a family member is a political dissident in Venezuela. He was moved to El Valley from California around March 6th. They actually tried to remove him on March 14th, but it failed for some reason, and then they told him he'd be removed the next day.
And WGH.
He had been living in Brooklyn, New York, arrested February 20th. An ICE form from March 7th identified him as a TDA gang associate. He was transferred to El Valley around March 10th and told about his removal on March 15th or 16th.
So all three detained in El Vale, all told they were being removed based on this proclamation and the AEA. Now, the legal path this case took was a bit winding, wasn't it? It didn't start in Texas.
No, that's right. The first lawsuit is actually filed in Washington, D.C. on March 15th, the same day the proclamation came out.
Fast action.
Very. That suit included JGG and WGH plus two others. They challenged the proclamation partly under the Administrative Procedure Act, the APA, and the D.C. court initially granted a temporary restraining order, a TRO.
What did the TRO do?
It applied nationwide and basically stopped any removals based on the proclamation, temporarily.
But that didn't hold up.
No. The government appealed, it went up the chain quickly, and the Supreme Court got involved. On April 7th, the Supreme Court dissolved that D.C. court's TRO.
Why? What was their reasoning?
They said the core of the claims challenging the legality of detention and removal under the AEA really fell under habeas corpus law.
The unlawful detention argument again.
Exactly. And habeas petitions generally have to be filed in the district court where the person is actually being held.
Which brings us back to Texas.
Precisely. So on April 9th, the petitioners filed their class petition for writ of habeas corpus in the Southern District of Texas, where El Valley is located.
And what were they arguing in that filing?
Pretty much the same core arguments. Removal under the proclamation AEA is unlawful, violation of due process, and they denied being TDA members. And they sought to represent a class.
Who did they want the class to include?
Their proposed definition was all non-citizens in custody in the Southern District of Texas who were, are, or will be subject to the proclamation and for its implementation.
Okay, a broad group. Did the Texas court react quickly?
Yes, very quickly. The same day, April 9th, the petitioners asked for another TRO, this time just for that district.
To stop removals from El Valley specifically?
Right, from El Valley within certain counties without a court order. And the Texas court granted that TRO. It was later extended.
So the removals were paused again, at least locally. What happened after the TRO?
They moved for a preliminary injunction, a longer-term halt. The court scheduled a hearing for April 24th to discuss that and the request for class certification.
Right.
At that hearing, an important thing happened. The government lawyers stipulated, basically agreed, they wouldn't try to remove the three named petitioners while the habeas case was ongoing.
Except under normal immigration law.
Right, except under the regular INA process. So that took the immediate pressure off those three individuals.
But the bigger legal questions about the proclamation remained.
Exactly. The court realized that the arguments for the preliminary injunction pretty much covered the core legal issues of the whole case, and everything was ready for a decision.
So they skipped ahead.
In a way. With no objections from either side, the court converted the motion for a preliminary injunction into a motion for summary judgment, essentially asking for a final ruling on the law right then and there.
And the class action part.
The court granted the motion for class certification on May 1st, 2025. It defined the class carefully.
How so?
As Venezuelan aliens, 14 or older, not naturalized, who have been or will be designated alien enemies under the proclamation and who are detained or residing in the Southern District of Texas.
Okay, so the stage was set for the final legal analysis. Let's get into the court's reasoning now. What were the key legal points they tackled?
Well, one of the first hurdles was an argument from the government based on the political question doctrine.
What's that in simple terms?
It's the idea that some issues are purely political, meant for the president or Congress to decide, and courts shouldn't get involved. The government argued that the president's power under the AEA and deciding if the conditions were met, like whether there's an invasion, were non-justiciable political questions.
Basically, court, stay out of this. It's not your job.
Pretty much.
How did the court respond to that? Did they agree?
They acknowledge the president has a significant power under the AEA, citing past Supreme Court cases. But, and this is crucial, they said courts still have the job of interpreting the law.
Meaning?
Meaning they can review how the AEA is being interpreted, whether it's constitutional, and critically, whether someone actually is an alien enemy under the statute. The court drew a line.
What was the line?
They said, look, we won't second-guess the factual claims in the proclamation about Venezuela and TDA. That stuff, they said, is a political question. We accept those facts as given for this case. However, the court insisted it absolutely does have the authority to interpret the words of the Alien Enemies Act itself, like invasion and predatory incursion, and decide if the situation described in the proclamation legally fits those terms.
So they won't judge the facts, but they will judge if the facts as presented meet the legal definition in the statute.
Exactly. They also noted the proclamation needs to have enough factual detail to even allow for that kind of judicial review.
Makes sense. What other legal arguments did the petitioners, the individuals, make?
They raised a few other points. One was about arguing the proclamation didn't give people a fair chance to challenge being labeled an alien enemy.
Okay.
Another was about removal timing. They argued the AEA implies people should get a chance to refuse or neglect to depart before being forcibly removed, which didn't happen here.
Right.
And then the big one, that the whole situation described in the proclamation TDA's activities simply doesn't legally count as an invasion or predatory incursion by a foreign nation or government as required by the plain text of the 1798 Act.
Let's take those one by one. How did the court handle the notice argument?
For the three named petitioners, the court said the notice issue was basically moot or irrelevant because they had clearly gotten notice and filed a lawsuit.
They were already challenging it.
Right. The court acknowledged it might still be an issue for other potential class members, but they didn't need to rule definitively on it because of their other conclusions.
Okay. What about the argument about needing a chance to leave voluntarily first?
The court looked at the whole statute. They pointed to another section of the AEA, 50 U.S.C. Section 22.
And what does that section say?
It essentially says that the president can allow time for departure unless the alien enemy is considered chargeable with actual hostility or other crimes against public safety.
Ah, an exception.
Exactly. And since the proclamation did allege that TDA members were engaged in hostile criminal conduct, the court concluded that the law likely doesn't require offering voluntary departure in this specific situation.
Okay, so those two arguments didn't carry the day. That brings us back to the main event, the meaning of invasion and predatory incursion. This seems like the absolute core of the decision.
It absolutely was. This is where the court did its deepest analysis.
What did the petitioners argue those terms meant?
They argued that back in 1798, when the law was written, invasion and predatory incursion clearly referred to military actions, like an army crossing the border.
And the government, what was their interpretation?
The government lawyers argued for broader, more modern definitions, things like a hostile entrance or any entry contrary to U.S. interests or laws. Something less. Military.
So a clash of interpretations, historical military versus broader hostile action. What did the court find?
The court sided strongly with the historical military interpretation. They did a lot of homework here.
Like what?
They dug into dictionaries from the period late 1700s, early 1800s. They looked at letters written by founding fathers, debates in Congress, court decisions from that era.
Wow, real historical detective work.
It really was. And their conclusion from all that was that the evidence overwhelmingly showed invasion meant back then an entry by a hostile army aiming for conquest or plunder.
And predatory incursion.
That meant something similar, but perhaps smaller scale. An organized, armed entry specifically to attack, plunder, destroy property, and then leave, like a raid.
So both terms implied organized armed forces engaging in hostile military-style actions.
That was the court's finding based on the historical record, yes. They also noted that the U.S. Constitution itself uses invasion in context suggesting military attack, like protecting states from invasion.
Did the court say a war or imminent war was also required for an invasion or incursion? Sometimes legal terms are read together.
That's a good question. They considered that argument using a legal principle called noscitur associes, meaning a word is known by the company it keeps, but they rejected it here. Because the statute lists the triggers disjunctively, meaning separately. It says, declared war, OR, invasion, or predatory incursion. So the court said you don't need a war for an invasion or incursion under this statute. They are distinct triggers.
Okay, so invasion or incursion doesn't require war, but it does require, according to this court, an organized armed force entering the U.S. to engage in destructive conduct.
That's the court's conclusion on the meaning of those terms. An organized armed force entering to engage in destructive conduct in a specific area. Doesn't have to be a prelude to war, but it has to be more than just crime or illegal crossings, even if widespread.
What about the other part of the requirement that the invasion or incursion be by a foreign nation or government? Did the court rule on whether TDA itself qualifies?
They didn't definitively rule on whether TDA by itself could be considered a foreign nation or government. It's a tricky question.
So how did they handle that part?
They pointed out that the president's proclamation explicitly attributed control of TDA's actions in the U.S. to the Maduro regime in Venezuela.
So the proclamation itself linked it to a recognized government.
Correct. So the court basically said, for the purposes of this analysis, the proclamation did identify a foreign nation or government, Venezuela, as being behind the alleged actions. They didn't need to decide if TDA alone would count.
Okay, so the foreign government requirement was met, according to the proclamation's own text. That puts all the weight back onto whether the actions described met the definition of invasion or predatory incursion.
Precisely. That became the make-or-break point.
And applying their historical definition, what did the court conclude about the actions described in the proclamation?
They concluded the actions, as described, did not meet the legal standard for invasion or predatory incursion under the AEA.
Even with all the serious allegations about crime, infiltration, and harming citizens.
Even with those, the court said the proclamation talks about unlawful infiltration, undermining safety, widespread criminal activity. But it doesn't describe an organized armed force entering to conquer or control territory, which is what their definition of invasion required. Nor did it describe an organized armed attack for plunder and destruction, followed by withdrawal, which is what predatory incursion required in their view.
So the type of harm described didn't match the type of action the 1798 law was aimed at.
That's exactly the court's reasoning. Therefore, they ruled the president's invocation of the Alien Enemies Act in this specific proclamation went beyond the scope of the statute. It was unlawful.
It really highlights how specific that old law is, and how the court refused to stretch its meaning to fit the current situation despite the government's arguments.
Yes, the court emphasized fidelity to the text and its historical meaning. It wasn't dismissing the potential threat of TDA under other laws, just saying this particular law wasn't the right tool based on the facts alleged.
Did the petitioners raise any other major points? What about the Convention Against Torture?
They did. They argued that using the AEA as proposed could violate protections against being sent back to a country where they might face torture, protections which are part of U.S. law via the Immigration and Nationality Act implementing the Convention Against Torture, CAT.
And what did the court say about that?
On that point, the court said it didn't have jurisdiction in this specific type of case, a habeas corpus action challenging AEA detention to review claims under the Convention Against Torture.
Why not?
They cited a specific statute, 8 U.S.C. Section 1252A4, and precedents from other circuit courts, which basically limit where and how SAC claims can be reviewed, and a habeas petition challenging AEA wasn't the right avenue, according to this court.
Okay, so they didn't rule on the substance of the torture claim, just said it couldn't be decided in this particular lawsuit.
Correct.
So, bringing it all together, what was the court's final conclusion and order?
The bottom line was that JAV, JGG, and LUGH, both individually and as representatives for the certified class, were entitled to habeas relief.
Meaning they won.
They won on the central AEA claim, yes. The court issued a permanent injunction,
Forbidding what?
forbidding the government respondents, DHS, ICE, etc., from using the March 15th proclamation and the Alien Enemies Act as a basis to detain or remove the petitioners and the entire class.
So a clear stop sign for using the AEA based on this proclamation against this group.
A very clear stop sign. But the court was also careful to add a crucial limitation.
Which was?
This ruling does not affect any detention or removal proceedings that might be happening or could happen in the future under the Regular Immigration and Nationality Act.
Ah, so if these individuals are removable under standard immigration law for other reasons, this ruling doesn't protect them from that.
Exactly. This was purely about the government's attempt to use the Alien Enemies Act in this specific way.
Okay, so summarizing the key takeaway. The court blocked the president's use of this very old, very specific law, the Alien Enemies Act, in this context involving TDA and Venezuelan nationals.
Right. And the core reason was the court's interpretation of what invasion and predatory incursion meant back in 1798, basically. Military-style armed actions, not just widespread crime or migration, even if directed by a foreign government.
It really underscores the depth of the court's analysis, going way back to the founding era, to understand the original meaning of these legal terms.
Absolutely. They didn't just look at the surface. They examined historical context, dictionaries, founding documents, past uses of the law. It was a thorough legal interpretation.
In this case, it really does throw into sharp relief that ongoing tension we often see, doesn't it, between legitimate national security concerns on one hand
And the protection of individual rights and adherence to the specific limits of laws on the other.
and it highlights the judiciary's role as an interpreter, drawing lines around executive power, even power granted by very old statutes.
That's a fundamental aspect of the separation of powers, and this case is a clear example of it in action. It reminds us that laws aren't infinitely flexible. Their meaning, especially rooted in history, matters.
So as we wrap up this deep dive, it leaves us, and you listening, with a really interesting question to think about, I think.
Yeah.
What are the longer-term implications here? How might this ruling affect future immigration policy debates or attempts to apply other historical laws to very modern 21st century problems?
That's a great question. Could we see other dusty old statutes pulled off the shelf? And how will courts interpret them if they are?
Exactly. What other historical laws might be re-examined, and what happens when their 18th or 19th century language meets today's world? Definitely something worth mulling over.
Food for thought indeed.
Well, thanks for joining us for this deep dive into a really significant court decision.